probate. I think you may have, man, right? How was the process? Was it good? Did you enjoy it? Was it okay? That's okay. Most people kind of give me the. That'll kind of give you a sense of it's not the place we want to be, so we don't want to avoid it. Limiting issues and conflicts between heirs. Did you know that money and death does? Huge problems, unexpected problems, even for some of the best families. It can create a problem. You want to watch out for that. Potential or protecting assets against creditors, divorce, tax, financial risk. What's a creditor? Well, when you die, the creditors don't just go away. Sometimes people think that. Well, I'm dead. I don't have to worry about creditors long. They get in line and say, "You still owe me. We don't care if you're in the ground. You still owe me. So we're going to get in line and try to get anything we can." So that's that. If you've got the probate, you know what I'm talking about. Predators. What's a predator? It's not some alien guy coming out of a spaceship trying to hunt people down. A predator could be a lot of things. It could be somebody who's taken an identity from a deceased person. That can be a huge problem for the family. Sometimes a predator is somebody who is related, married to, friends with an heir who feels like they deserve part of this. Maybe they think that their spouse deserves more, and they start causing problems and issues. That's a predator. It can cause dynamic problems in the family. Establishing guardianships for minor children or special needs adults. If you have children that are under the age of 18, you need to plan for them if you're not here. Who gets them? Who takes care of them? How are things handled for them financially? Those are things that are important. If you have somebody who relies on you as an adult, special needs individual, that needs to be considered. Essentially, estate planning is ensuring what you want to happen actually happens at the time you want to happen by the people that you want it to happen. That's it. So we're going to figure out what's an estate consist of. It's your stuff. That's it. It's your property. It's your car. It's your investment account. It's your bank. It's your life insurance. It's your snow globe collection. It's the Christmas plate that's been passed down over the years. It's chattel. That's not cattle. That's chattel. Chattel is everything that's not kind of nailed down. However, cattle is considered chattel. So you have it, and then I'm going to argue that your legacy is part of that. That's part of the plan. That's what the estate consists of. So how do we deal with those things? When you die, there's a final destination for your stuff. At that, there's 3 locations your stuff can go. Number 1, probate. Probate, I'm going to talk about in just a minute, but I got a life insurance policy. I've named Nick as my life insurance beneficiary. I die, he gets it immediately. Does not go through probate. You can do the same thing with bank accounts. You can do the same thing with your 401k. You can do those by operation of law. It's a valuable tool in estate planning. It's not the only tool. Sometimes people overly rely upon this and there's issues in it. Or number 3, it goes to a trust. A trust is a central hub. A trust basically is where everything kind of connects together. I always describe a trust as like a hull of the ship, and I'm going to give you a couple other analogies that you'll remember a little bit later. Some you might like, some you might not. We'll see. So, what's probate? The probate essentially is the legal process of resolving claims and distributing the estate. That sounds pretty good. No problem. Okay, cool. Let's do probate. What's the objectives of probate? It appoints individuals to manage your affairs. It resolves disputes, pays creditor, appraises assets, formally inventories, changes the title, and distributes the assets. Let's break this down a little bit. Probate. Guess how many people in the United States today do not have an estate plan anymore? Does anybody guess the percentage? You're a little high, but you're close. 70%.
Wow.
70%. So how many people are here today? 10, 11, 12 people like that? So if there was 10 people, 7 of you don't have a plan. Woo! That's crazy. That is absolutely crazy. So the problem with that, if you die without a plan, if you die without a plan, guess what happens? You're going to probate. Why is probate a problem? If you don't have even a simplified plan, the statute appoints who's in charge by priority. That might not be the person that you want. That might be the person that you thought about that was like, I don't want that person in charge. If you don't have the plan, guess what? You're stuck with it. You may be dead and don't care, but the rest of the family might care. It might be a problem. Resolve disputes. That sounds pretty good. Courts resolve disputes, don't they? I don't know. I always find that if I negotiate things, I resolve things a little bit better. Courts are where you fight over stuff. That's why there's so many lawyers, and that's why they charge so much, because people like to fight over stuff. It does not resolve disputes. It will ultimately, but a lot more disputes arise through probate. Pays creditors. Like I said, they're there. They get in line. They want their piece. They better get paid. Whatever's left. Appraise assets. We need to figure out what all this stuff is worth. So now we got to hire appraisers. Appraise a house. Maybe a car. Maybe we got a business. Maybe it's a small business we got to appraise. We got to figure out what the value is. All of a sudden we're starting to pay money. Formally inventories and assets. Exactly. Well, what that is once we appraise all the assets, we add them all up. That's the inventory. That's what your state's worth. Could be 10 grand, could be $1 million. Could be 10 million. It doesn't really matter. But what happens once you inventory it, you have to pay an inventory fee. So they calculate what your assets are worth, and then you pay the local municipality a fee, the courts. Where does that go? I don't know. I have no idea where it goes. It just goes into the administrative hole, I guess. But it's a cost. It's expense to the estate. Then we change the title. So you got to change the title from the deceased to the estate or whoever is inheriting it. Now we get to the point where we can distribute the estates. So we got to go through all of this stuff before we get to distributing what's left. So what are the reasons to avoid probate? Creates avoidable unnecessary problems. Money and death cause problems, period. If you've never experienced it, you will. I've had families be torn apart over 15 grand. I kid you not, I have a client specifically in mind. They do not, none of them, there's two sisters and a brother, none of them talk. Fighting over $15,000. It was in a small state, it wasn't even a full probate. 15 grand. Crazy. It's a lot of money, don't get me wrong. Not enough to tank your family. Crazy. Give me my money. Creditors, and people who think they want. Give me my money. So, late fee. Probate takes time. Minimum in Michigan, it's a full probate state. It's over the exemption rate. There's a small exemption rate for small states. 4 months. That doesn't seem too bad. My average probate, 18 to 24 months. I try not to do probates for my clients, but some of them die without a proper plan. They come to me and I got to deal with it. 18 to 24 months. Why? Well, we got to deal with creditors. We got to deal with disputes. We got to appraise the assets. We got to inventory them. We got to change title. All of that stuff takes time. And guess what? The courts do not do it quickly. When I said it's like the DMV, it's like the DMV. It's very, very slow. Number 3, it's expensive. Probate is not cheap. It's not that you can't get it done inexpensively, but the average cost of probate is 3 to 8% of the estate. That's a lot. If you have a $500,000 estate, 3% is $15,000 out of the estate. That's a lot. Now you might say, that's a lot of money. It's $500,000. Well, let's say you got a house that's worth $350. You got a small 401k. You got some cash. You got a car. You got some personal property. You're at $500,000 pretty quickly. You might not even realize it. Some people sit around and they're like, I'm a millionaire? Yeah. You add it up, you add up these things, and then all of a sudden you're there. Even $100,000. 3% still $3 grand. And if people are fighting over it, you're pushing down 8 or 10. $500,000 there is $40,000. And that goes to the courts, it goes to the appraisers, it goes to the lawyers, it goes to the creditors, it goes to everybody else in between. Tax man, but it doesn't go to the heirs. It's a problem. Lastly, it's public. Court proceedings make your estate, your finances, your heirs public. I'm a big fan of saying family business is family business. I don't like people knowing what's going on behind closed doors. That's for the family to work out, not the community at large. So if you're in court, you're in probate, court proceedings are public. If you want to know what's going on in your neighborhood? Go down and check out the filings. You can find out who's been arrested, who's been in wars, who's
Yes,
been
you
sued.
can.
It's all there. It's better than AMC TV. So what are the most common estate plans? There are probably 5, there might be a few more. Number 1 is die intestate. That's a fancy lawyer way of saying, I've died without a will. 70% of people are going to die intestate. Which means, guess where they go? Probate. Their estate's going to probate. Number 2, I have a will. Last will and testament. That means I die intestate. Sounds a little bit better. So one way to get probate. You can have a will, but it doesn't activate until you open a probate estate. The will does help, though. It provides direction and it's a roadmap to the courts. We'll talk about how a will help with the estate planning process. Number 3, spend it all. That's my favorite. This year I was trying to convince my wife to spend it all. I'm thinking beaches and Mai Tais and just good weather everywhere, not Michigan weather. But I thought about it and said, well, if I live another 40 years, life might be a little tricky for me. So spend everything's not always the greatest choice. Unfortunately, more often than not, people do spend everything unintentionally. Why? Well, the last 3 years of your life are going to be the most expensive. I would argue that the last 3 years of my life with my kids in gymnastics was the most expensive, but statistics will say that the last 3 years of my life will be the most expensive. So, why? Well, we get older, health deteriorates a little bit, medical costs increase, we need more. We're not spending it on things that we want, we're spending it on things that we need. People are living longer, but not better. So that's somewhat problematic. So some people, unfortunately, die impoverished because they've spent it on medical treatment and care. Joint ownership titles. This is a good way to do it. This is part of our arsenal here. What does that mean? Well, let's say we have a house, and somebody else owns the house with us, and one of us dies, the other one still owns it. Same thing with transfer on death for bank accounts and life insurance. It's a good tool. It's not the only thing, it's a good tool. And the last is a revocable living trust. This is the central hub of most estate planning. Not everybody needs a trust, but a good chunk of people do. So we're going to talk about why. So what are the top planning mistakes to avoid? Having no plan at all is the number 2 plan, I would say. And number 1 and number 8 kind of go together. But having no plan at all, that's a mistake. If you don't have a plan, you're planning to fail. That's kind of the age-old thing. Number 2, incorrect beneficiary designations. Is our stuff going to the right person? You'd be surprised how often it ends up in the hands of the wrong person by no fault of the person who died, just simply because they did something mildly happens. Do you know the difference between tenants and entirety? Tenants in common, joint tenants. These are designations for real estate, but they also apply to other assets. Do you know what the difference is? If you don't, you might have incorrect beneficiaries. It's not title covered. Using internet reform documents, what I like to call legal boom, trademark pending. I wish I could stand it out when I do that legal boom. I don't have a problem with DIY. The problem with it, though, that happens is you're typically not going to know that there's a problem until it's too late. I had a client come in about 6 months ago. He said, I just want you to do a quick review. I already drafted my plan. I said, great, bring it in. He's like, and I said, did you draft this? He goes, yep, every word. I said, really? He goes, yeah, every single word. I said, right. He goes, no, I didn't. I did my research. I drafted it. And I said, well, where do you live? Downtown Kalamazoo. How long do you live there? 30 years. Planning on dying there? Yep, not moving. You're not planning to move to California? Nope. Well, why did you write a California will?
Oops.
He all of a sudden had to admit that he just printed one off. So, which is okay, but the problem is, who can guess that different states have different laws?
Yeah.
States like California and New York and Florida and Louisiana and Texas have vastly different laws. You know, you can just look at it and be like, man, those people in California doing something weird again. The laws are different. Things are just different in different areas. Unintentionally disinheriting heirs. May end up gone bad. I'm going to talk about this a little bit more. But let's say we say, hey, I've got a bank account. I'm going to put my son or my daughter on there as the pay on death beneficiary. We're good. No further planning needed. And they die. Where does the asset go? Probate.
Probate. Yeah.
What happens if they're incapacitated and they get a bunch of money? And it disqualifies them for their assistance.
Wow.
That's not what we want to do. Having the correct people selected and also have the correct powers if you become incapacitated. I've joked about this a couple times, but it's really important. If you have the wrong people looking out for you, you're not going to get the care treatment that you need. Failing to protect your assets from the IRS, creditors, predators, divorce, bankruptcy, family issues, giving minor spendthrifts inheritance without parameters. What is that? Well, let me tell you. I'm going to set you a scenario. I'm 18 years old. I inherited a good chunk of money from my parents. And with that money, I made the great investment of buying a jet black Corvette with the top down. And I was going 90 miles an hour on the highway. I had the prettiest girl that would talk to me in the seat next to me. Money was flying out of my pocket, but I didn't care. I had enough, and we were on our way to the best steakhouse in town. By 19, I didn't have much left. That's a fixed story. Not the Corvette. I probably would have still bought the Corvette. But the fact of the matter is at 18, I wasn't ready for money. I didn't know about it. I mean, you don't have to be young to not be ready for money. Right. There's people that are in their 50s, 60s that all of a sudden they got $100,000 or $500,000 or $1 million inherited IRA. They don't know what to do with it. Have you ever heard those lottery stories when the guy wins like $8 million and he's broke the next year? And you go, how does that even happen? They're not ready for it. It can be a burden to some people. A lot of parents sit there and go, hey, you know what? We want our kids taken care of. Well, if you're not planning for how they get that and they're not ready for it, you could be giving them a curse. And unfortunately, it does happen more often than I'd like to admit. Ensuring your heirs, this is the biggest mistake, ensuring your heirs do in fact go through probate. Nobody wants to go to probate. Nobody has a good time in probate. I think we had one guy at a presentation who said, probate was great! But he also told me that after the presentation, he said, nobody owns everything, the government controls us all, so watch out for this.
I know which guy you're talking about. Yeah, no.
He was a very nice man.
But very
He had different beliefs. I am very accepting of all my clients. Everybody has unique families, everybody has unique backgrounds. I slightly disagreed with this gentleman on his probate experience. So, I'm going to make my joke. This is a matter of life and death, people. I have one snicker. Nobody ever laughs at that. Yeah, that's pretty bad. But what we're talking about life planning and death planning, right? Life documents, death documents. Life documents, power of attorney, living will, advance directive. That has to do with money. That has to do with health. While we're here. Death documents, last will and testament. Where's my stuff go? Who takes care of my kids or my special needs adult that I care for after I die? That's it. A trust overarches both of these, and we're going to talk about that. Down below, I don't know if you can really see it, but this is a comprehensive plan. Revocable trust, last will and testament, revocable power of attorney, medical directive, and properly funding and removing assets from identities. So, what's a durable power of attorney? A durable power of attorney, or a financial power of attorney, allows somebody that you trust to step into your shoes to do financial and legal stuff for you. So think it's Saturday, I gotta run errands. I gotta go to the bank, I gotta file my taxes, I gotta pay the cable bill, I gotta deal with the medical bills, I gotta pay the insurance. If I can't do this, who steps into that role? And who do you trust to step into that role? Why does it matter? Well, without having one, friends and family aren't allowed to make important financial decisions. If you're still here, life continues. Guess what? Creditors still want to be paid. Taxes still need to be filed. If they don't have the authorization to do that, life stops. And if you get better, that's a huge problem you don't want to wake up to. So, manage investments and financial decisions. This little cartoon says, don't panic, it's just a correction. It's true. That's what a financial power of attorney does. It allows somebody to take the wheel and correct it when life is kind of flying off the rails. Having a plan is super, super important, and this is kind of the first piece. So, healthcare patient advocate gives a designated person the authority to make healthcare decisions for you. If you are ill, whether it's your body or your mind, Somebody needs to step in and make that decision for you. If you have Alzheimer's, dementia, early onset Alzheimer's, maybe you're in a coma, maybe you're physically limited to the fact that you can't make the decision. Who shares your values and beliefs to make that decision for you? If you don't take anything else from this presentation, get a medical power of attorney. This is the most important document out of everything that we do because it has to do with your health and if you are sick. Everybody has 1,000 problems. When you're sick, you have one. So this is really, really important. It also authorizes HIPAA release of information. HIPAA is the Healthcare Accountability and Portability Act or something like that. I think I got that right. Healthcare Portability Protection Act. Anyways, what it is who the medical providers can talk to. So, bam, mom's in an accident. I'm on my way to the hospital. I'm driving 100 miles an hour in my black Corvette. No, I'm on my way down there. I get to the hospital and they say, Doc, what are you doing for mom? Did you know they can't tell me?
That's right.
They usually do. Guess what? They're violating HIPAA. They shouldn't tell you. That's a huge problem. And what happens when you're in the spot where something needs to happen, and now it's just up to the doctor? You don't have any say. You don't know what the heck is going on. That's why medical power of attorney is so important. Living will. A living will instructs care providers end-of-life transitional stuff. This doesn't always happen, but it says if death is imminent, permanent vegetative state, or an incurable condition, do I want to be kept alive artificially, invasively to prolong dying? This happens in tragic situations: stroke, catastrophic heart attack, catastrophic accident. You rush to the hospital, you're hooked up to life support, they say there's nothing more we can do. Who makes the decision whether or not you need to be taken off life support? I'd argue that's a personal choice. You might want to make that choice yourself. Take that burden away from the family. I had this happen to me, unfortunately. My law partner, who just retired, his wife about 2 years ago went in to get a heart stent. Pretty simple procedure, it was outpatient. She had some cardiac issues. She went in, had the heart stent. She came out, went well. They went home, they had dinner, they went to bed. He woke up. She was completely non-responsive. He rushed her to the hospital. He calls me on the way in. It was about 7:15 in the morning. I said, hey, Bill, what's going on? He's like, listen, are you at the office? I said, no, I'm on my way. When you get there, grab my estate plan. I need the living will and the medical power of attorney. No questions asked. I get there, I grab it. I get his plan for him. I run it down to him. What's going on? Marilyn had a stroke. She had blood clot, completely non-responsive. They hooked up to life support. There's nothing more they can do. Tragic situation. We then give the living will to the hospital. Family got to come and say goodbye. They took her off life support. She passed away about 6 months later. The thing that's really important about this is when we sat down and did her plan, she told me, listen, something happens like this, I don't want my family having to prolong and delay in getting to breathing. I never thought in a million years this would actually happen to her, but it did. And sure enough, her family got to start breathing immediately. It was not a long process. Cool little tidbit to this story. Bill told me she was a very loving, most beautiful woman. Loved God, very devout Catholic. He told me when he kind of was lifting her up, he tells me that she made the cross, which I thought was just pretty darn cool. So, just a really neat little tidbit to that story. Bill told me that, and I almost cried. Pretty tough. So, let's talk a little bit about guardianship and service. If you're incapacitated physically, and you can't take care of yourself, a guardian needs to be appointed. Where do you get a guardian? If you can't handle mentally your dollars and cents, you need a conservator. They are different. Guardian's person, conservator is money. They sometimes and oftentimes do go together, but they don't always have to. You have to go to probate to get that. But you can avoid it by having a patient advocacy and power of attorney. You put those in place, you do not go to probate. Having a loved one sit in probate who's suffering from dementia with a guardian ad litem, which is a court-appointed lawyer for their behalf, they don't understand what's going on. That's a pretty tough thing to go through. these medical power of attorneys and financial power of attorneys avoid that. So, let's talk about deeds. Let's talk about houses and property and how that works. So, this is a key part. If you own real estate, it's usually one of the bigger assets that people own. And how do we transfer it? Well, if you own the house fee simple or in your personal name or you and your spouse's name, and both of you are dead, it goes to probate. Because you have to specifically assign title. Well, we can transfer property through deeds. One of them is quitclaim deeds and warranty deeds. There's a bunch of different ones. Quitclaim is what we use most often. And what is that? That is, I'm quitting my claim to this property and I'm giving it to somebody else. Okay, not a quick claim. It is quick, but it is quitting the interest. It's an immediate transfer of ownership. It's a good way to transfer property, but there are risks to it. Number one, it creates Medicaid and tax issues unexpectedly. So, if you are running out of assets and you need Medicaid, Medicaid does not let you have lots of assets. In fact, they make you spend it down to about $2,000. Now, there are some exemptions and certain things that are exempted, but if you have a piece of property that's worth a lot of money, it doesn't even have to be worth a lot of money. Let's say it's worth 50 grand. They're going to look at that and say, hey, that's an asset. You don't qualify for Medicaid. So what people do is they say, haha, I'm going to transfer it over to my kid. So I'll just transfer this property to my kid. I all of a sudden now am completely impoverished. I can qualify for Medicaid and get my long-term care. That sounds like a pretty good plan. Medicaid has what they call a 5-year look back, which means if you transfer property or something out of your name with the anticipation to qualify for Medicaid, they will claw back and disqualify you from Medicaid. You don't even have the asset in it, and you're completely disqualified from Medicaid. People do this all the time and do not realize that they are messing with Medicaid. They are smart people who make it very difficult. They don't want you to get rid of assets. If you have them, they want you to pay first. Tax implications. What am I talking about? Well, let's say I bought a house in 1980 for $20,000. I've lived in this house for 45, 50 years. The house is now worth $500,000. Pretty good appreciation. I do have some exemptions because me and my spouse have lived there, so if we sell it, we can avoid some capital gains. But I start to think, I want to avoid probate for my loved one. Let's add my son and my daughter onto the house. We'll just add them to the deed, no problem. Cool, they're on. Now suddenly we live another 20 years. We added them at $550. Now we pass away. The house is worth now $800. Well, your basis when you bought it was $20,000. The appreciation is now worth $800. We added the kids at maybe $500,000. When they sell at $800,000, they're going to have at least a $300,000 capital gain bill and maybe an $800,000 capital gain bill. We don't want that to happen. That is a lot of money to pay on a house that you inherit and you have to sell it. There's a simple way to avoid that. With inheritance, the basis for when I get it upon death is $800. So now when I go to sell it immediately, guess what my tax is? 0. So people add deeds, they completely miss it, and they give their heirs a tax burden that they did not anticipate. Lady Bird and enhanced life estate deeds. Who's ever heard of a Lady Bird deed? Ever heard that term? A Lady Bird deed is essentially a transfer on death deed. It's the same thing as an enhanced life estate. Essentially what we're going to do is we're going to deed it to ourselves for life. When we die, it immediately transfers to who we've outlined on that. Why is that important? Number one, it avoids Medicaid recovery. You're not giving the house away because you're giving it to yourself for your life, and you no longer own it because it's life estate. So now all of a sudden we can still qualify for Medicaid. This is one of the key tactics that we do for Medicaid planning. Number two, it avoids tax issues. If the house passes upon death, our heirs get what they call that step-up in basis from 20 to 800,000. They now get that step up because they're inheriting it upon death. So this is a tactic that we use to help transfer property. This is one of the tactics that we use as part of the estate plan to make sure things go correctly. Can I prepare the deed? Well, you can, but there's a couple things to worry about. Legal issues. If you don't understand property law, deeds are very complicated. They're only 2 pages. They seem really easy, but there's a lot of nuances with them. Unexpected tax consequences if it's done right. If you file a deed transfer and you don't file it with a property transfer affidavit saying that it's exempt from property uncapping, you're going to uncap your property taxes unexpectedly. All of a sudden your property taxes go up. Now they treat it like a resale and they raise it up. Medicaid eligibility issues, already talked about that. Improper owner designation, if we put the wrong name, we might have given it to the wrong person. Or at least, we have to go through a court process to confirm it's the right person. That's not fun. Wrong property. Who's ever seen a legal description? The northeast corner, the southeast corner, the southwest side, the 14 rods north to the point of beginning. You know what I'm talking about?
He's lot.
Yes, in lot 46 of the southwest woods of, Calhoun County. Yeah, absolutely. It is ridiculous. When you put an identifier on a deed, it's not the property address, it's not the parcel ID, it's the legal description. And if you get one thing wrong, instead of the southeast corner, you put the southwest corner, you just transfer property clear across the county to somebody else. It's not even yours.
Wow.
Can you do that? I've seen it happen. Problem is if you mess it up, now all of a sudden you gotta go to probate, and we get bonus, we get second lawsuit, which is quiet title action. So now we've opened the probate, now we file another quiet title action, we get that all sorted out, we're back to probate, now we can disperse the property. It takes time and it takes a lot of money. So, beneficiary designations. This is a good way to transfer it. Pay on death, transfer on death, tenants, an entire joint tenant. Pay on death I already talked about. You die, Bank of America transfers it to who you've listed. Transfer on death, same type of thing. Tenants in entirety. This is certain ways to take real estate. Does anybody know what a tenants in entirety is? Okay. If you are a married couple, and you own property together, you own it tenants in entirety, which means you both own 50% and you both own 100%. Kind of weird. So if one of the spouses dies, the other spouse has 100% of it. The other cool thing about this is it's inadvertent asset protection for you. So if one of the spouses is sued, they can't come after your house if you own tenants in entirety, because the other spouse is not listed on the house. Joint tenancy with full rights and survivorship, or tenants in common. These are the other two ways to take real estate. You can take other assets this way. Real estate's the most common. Tenants in common is the most common way to take real estate. Joint tenants is a different way, and it's a last man standing. So, me and my two siblings own a property together. Sister dies. Now it's me and my brother. We own it 50-50. Brother dies. I'm the last man standing. I own 100% of the property. That's joint tenancy. Tenants in common, 3 of us own it. Sister dies. Her kids get her 1/3. Brother dies. His heirs or beneficiaries get 1/3. Now, I still own my 1/3, and I'm dealing with 400 or 500 people that own the other 2/3. That might be how we want to transfer the property, but maybe not. So it can create problems. If done incorrectly, the wrong heir can inherit. For example, we have a pay on death transfer. That person dies before we do. We are now in probate, and now it's going to some other heir or beneficiary that we didn't plan on.
Can I share my?
Actually, yeah, this is actually good.
That's
good story. I was going to set it up. So Nick actually has this, a good little story, so I'll have, thank you, seriously. Much appreciated. So go ahead, Nick.
This is literally going on with me right now. So I have a personal family situation. Unfortunately, so my dad, how do I make this short? Okay, so dad unfortunately passed of pancreatic cancer as well. It'll be 10 years in December. Dad's real father passed when he was very young. Grandma, his mom, got remarried. They had 4 kids. Dad's stepfather adopted him, but did not treat him well, and ended up kicking him out of the house when he was 16. Fast forward many years, I was very close with Grandma, and Grandma was the glue. Grandma passed away in 99. When Grandma passed away, the family went kind of their separate ways. So I haven't talked to my aunts and uncles for about 15 years. I get a call in February. Stepfather passed away last June with a will. Very detailed will I made. So he died testing, as Phil said. My uncle, who was the black sheep and the oldest boy of the 4 natural kids of stepfather and grandma, never moved out of the house, took care of stepfather the last few years of life, inherited about 85% of the estate. The other 15 was split between the two other boys. And I get a call saying that oldest son, my uncle, passed away while stepdad's estate was still in probate. So when he says probate if beneficiary dies, so now uncle passed away, was getting 85% of stepdad's estate, and uncle passed away intestate without a will. Because I was part of the bloodline, I'm getting 25% of the entire estate, which stepdad would be rolling right now. Dad and grandma are probably smiling because they're saying, well, karma, I'm sorry, but you know. So that's a story of even a will is not sufficient, and most people think it is. And even at worst case, pay on death beneficiaries, that would have avoided it for stepdad. If stepdad would have had pay on death beneficiaries and not had everything go through the will, that probably would have been enough to avoid probate. And he didn't get it.
The best part of that story is when Nick first called me, he said, I got this call, and he said, there's been a death in the family.
Oh, that is I left that part out.
There's been a death in the family, and you're involved, Nick.
My uncle left that voicemail.
Wow.
And
When he told me that, I laughed.
I called him back, I said, first of all, don't ever leave a voicemail. I haven't heard from you since my dad's memorial, and you call and leave that? I feel like, am I looking for the FBI? What did I do wrong?
Okay, so we can have some issues. So Heath Ledger is an example. I like that story a little bit better, but Heath had a beneficiary designation estate plan. All of his money was going to go to his brother and sister. I think it was he had a brother and sister, which was great. That was fine. He had investment accounts. It was all set up. They were just going to take that upon death. He had a daughter. He then died. Guess where his estate went? With the brother and sister. They were paying the beneficiaries. His daughter got completely disinherited. That was not his plan. The good news is, in this story, the family actually did the right thing and gave the daughter the money back that she was not legally entitled to. So that was he had a plan. He failed to change it when his life changed. He had a daughter. He should have updated it. His legal team should have updated it. A couple other famous failures. We got Tony Soprano here. Tony didn't look at taxes. And now in The Sopranos, he was always about dodging taxes. He didn't really think about it in real life. So he left 20% of his estate to his wife, which included a very, very extensive art collection. The whole estate was worth about $100 million. He didn't maximize tax exemption planning with a spouse. So when he died, 55% of the estate, $55 million went to the tax man.
Ouch.
People were not real happy about that. Prince had another one. He had a $300 million plus estate. When he died, he had no estate plan. When he died, guess who showed up? Everybody showed up! Come on! There was some money there. 6 years later.
They know me though.
Exactly. 6 years later, tens of millions of dollars in litigation costs, it finally was dispersed to his sister and his 5 half-siblings.
Wow.
6 years, tens of millions. Not 10 million, tens. It was like $30, $40 million. So, last will and testament. Let's talk about that. The last will and testament is a roadmap. That's all it is. It's a roadmap to the probate court that says, this is the person that I want in charge. This is where my assets go. And if I have a young kid, this is who takes care of my child. That's what it does. It's important because we're not subject to the statute. We're not subject to everything else. We're making the decision. This is really key. We have a little bit of control now. We have a legacy that we can start to build forth. But if you have a will, it is a one-stop ticket, or it's a one-way ticket to probate. The will does not work without probate approval, which means you need letters of authority from the probate court. A lot of times people come in and say, here's the will, Phil, let's disperse the assets. Can't do it. You gotta run through probate. You go down to the bank, they don't care if you have a will without the letters of authority. You need the probate court to do that. That is a big misconception with wills. Not a big deal, but we do have to go through probate. So it's a one-way ticket there. Trust. So how do we avoid probate? Well, what's a trust? A trust is a legal document created by you, the grantor, during your lifetime to bypass the cost and consumption of probate. That's what it does. So let's walk through the elements. A trust is comprised of 5 things. Grantor, that's the person who sets it up, most likely you. Trustee, that's the person who controls it. Again, probably most likely you until you're incapacitated. Then we have a successor trustee set in place. Number 3, corpus. That is a dead body we hide in the backyard to avoid the tech. No, I'm kidding. Corpus is the trust assets. It's the legal term. It's the funny legal Latin term. But basically, it means trust assets. That's all it is. We have terms. That's the instructions. And then the beneficiaries. And the terms basically say who gets it, what do they get, when do they get it, how they get it, and if there's any limitations. There's mud. Let's clear it up. It's a pickup truck. Nick's not a big fan of my pickup truck analogy, but I love it. So bear with me. If you don't like it, write it on our response sheet and say, get rid of the pickup truck analogy.
It would make my whole day.
It does. But I'm going to win you guys all over. You're going to love it. So, a pickup truck is a vehicle. A trust is a vehicle. That's all it is. We buy this vehicle, we put it together, and we are now the drivers of this pickup truck. We are the grantor trustees. We control this vehicle. Trustee grantor controls the trust. Driver controls the truck. All of our assets, the corpus, goes into the bed of the pickup truck. That's your real estate, that's your cash accounts, it's your investment accounts, it's paying death beneficiaries for IRAs, 401ks, life insurance, personal property, snow globe collections, whatever. It all goes into the bed of the pickup truck. Now we drive it. So instead of carrying our stuff like this, we're riding inside. We've got a truck that carries all our stuff. So wherever we go, our stuff goes with us. Doesn't matter where you have it. I don't care what bank you have. I don't care what investor you use. I don't care what advisor you use. I don't care where your property is. It's all part of the trust, owned by the trust. Now, if we can't handle things, now all of a sudden we got to have somebody drive for us. So we slide to the passenger seat and we appoint a new driver. That new driver is our successor trustee. They follow our instructions. They take stuff out, put stuff in for our benefit and the benefit of the people that we choose. Then, beneficiary. After that person dies, number 1, it does not drive us to probate. It completely avoids it. We don't need it because all the stuff is in our trust. It's in our bed of our pickup truck. We look at the GPS, which is the instructions. It says who, what, when, where, how all these assets go. How does that work? Well, I have 2 little girls. They're 8 and 10. I already told you they're gymnastics stars that are bankrupting their father. But the interns are really expensive. I did not realize that. It's crazy. But if I and my wife were to pass away, I don't want them getting a bunch of money at 18. I don't want them getting a little money at 18. I don't think they're probably going to do anything. I would be driving the Corvette. They're probably going to be doing the same. So we have it set up where that money is there for them. We've got our guardians and stuff taken care of, but that money's set up for them to make sure that things are taken care of. School is paid for, health is paid for, the things that they need, it's there. Our life insurance is set. They don't control it though, the trustee does. Now when they reach 25, they can take 25% of whatever's in there and do whatever the heck they want with it. They can spend it on a world trip. They can send it to the Prince of Zimbabwe if they got that email, I don't know. So, but it's still 75% is still left in the trust. At 30, they get another 25%. They do whatever they want with it. At 33, I figured they haven't figured it out by then. It's all yours. And you're good to go. But the idea is, I've got it set up because I don't know what it's going to look like for them. So I have some guardrails in place. I've got some pinnacles that they have to reach to get that, and it's simply to protect them from themselves, from predators, Maybe they're suffering from an addiction, drugs or alcohol or something like that, gambling. We want to make sure that they're protected from themselves. So that's what the instructions GPS are going to do. So what are the benefits of trust? Number 1, probate avoidance. We do not go to probate. We do not need authorization from the court because the trust owns the assets which you control. So as long as you're alive and healthy and able to do it, nothing really changes from day to day. Assets protection from heirs. When it's held in trust, they don't own it. So we have asset protection. They have asset protection from taxes. We have asset protection from creditors or lawsuits. We have asset protection from themselves, bad spouses, whatever it might be. And we can structurally design that however we want. Control. You have control of who, what, when, where, how it goes out. I've got some limitations in my trust. Everybody's a little bit different. Sometimes it's not right. Hey, we died. Follows in the trust. We disperse it out. That's okay. It doesn't have to be tiered out. But you can. You can have milestones. They got to graduate from high school. They got to graduate from college, whatever it might be. Privacy. Family business. It's still family business. It's in here. It's not part of the community at large. And lastly, it's capable of mitigating taxes. If you don't have $13.6 million or married $27 million, you don't necessarily have to worry about tax efficiency right now. But that will sunset down to $7 million. So if you don't have $7 million, you still probably don't have to worry about that. But I do caution you, tax exemption limits are set by the legislature, which means they can drop it down. Now, are they going to do that? Probably not. It's not going to happen. But I always argue that if you need to raise taxes, who do you raise taxes on? Dead people. Because they came from a god office. So, I already have a plan, Phil. It's now the time to review. Why? A couple reasons. Number one, we've had some life changes. Tax issues, expanding family, grandkids, diagnosis of illness, retirement. Those are all things that play into it. We've got new assets. We bought something. We sold something. Our relationships have changed. I named my brother 20 years ago. He's not the best choice now. Or, you know what? Our kids are grown. We want them incorporated into this plan. We want them making decisions for us now. I made this decision for them. They're going to step into that role. Secure Act 1 and 2.0. The rules have changed. In 2019, 2022, the rules for inheritance, specifically IRA inheritance, significantly changed. What this means is it used to be what they call a stretch, which means you can take it over as long as you want, so you can minimize your taxes. IRAs, you still have to pay the income tax on it. Okay? Now, with Secure 2.0, if it goes into the trust, you may be taxed at a 38% tax rate if you don't have a see-through provision. And number two, you will have to take it over a 10-year period, which means regardless of where you're at income-wise, you're going to have to deplete the inherited money over a 10-year period. That can be a problem. I had a client that came from California. He was a high-income earner. He also lived in California. He was inheriting $1 million from his mom's IRA. Unfortunately, his tax rate was going to be 68% on that money. That's a huge burden. $680,000 and $1 million inheritance is huge. It was, they're going to take it all. Anyways, the nice thing was, we were able to navigate in the trust, because all the assets filtered in, or we redistributed some to the grandkids, some to the nieces and nephews, some to his lower earning spouse. We took a different asset, we gave it to him, we worked it out, and he ended up paying nothing in taxes, which is pretty cool.
Yeah.
So, what about the goat? Oh yeah, the goat. So, I'm sitting down with Ron, we're having this discussion, he said, we have the new plan. We have the plan. What's the plan? And I said, well, you went from scientist to attorney, karate sensei. What's this new plan? He said, Sue and I have decided we're going to be goat farmers. What? Goat
Wow.
farmers? They had a passion for sustainable farming. So they opened a goat farm, and now they produce goat cheese. And it's absolutely delicious. Wind Shadow Farms. Really good. But the whole point was, at each stage, Ron would always talk about plans. He'd always talk about what's next and how to get there. And that lesson was important. And then he shared with me, during this conversation, he said, listen, I would have made this decision had it not been for Sue, and I want to make sure that if I'm not around, she can still live her life and her dreams. So Sensei Ron's wisdom was, he told me, if you don't have a plan to take care of who you care about, you're planning to fail the ones that matter. And that has stuck with me to this day. So, time to execute the plan. I'm not the typical estate planning lawyer, as you could probably imagine. Kind of loud and boisterous and not what you'd expect out of an attorney. I did wear a suit today, but that's all right. But when I look at estate planning, I look at a larger picture. We look at a holistic viewpoint. A lot of times, people will put together a plan, they'll put together their estate plan, maybe got a financial advisor, so that they're working with at the retirement, for their business, they've got a CPA or bookkeeper, and each one of them have a plan. And the plans are all working. And they're these little islands, and they're not connected. And not one of them talks. Guess what? If they're not connected, you think all the plans are going to work efficiently? If the defense coordinator and the offense coordinator for the Lions don't talk, are they going to win games? Maybe a couple. They get lucky. Problem is plans deteriorate. This is where coordination, tax horizon planning, asset protection planning, life insurance needs, long-term care risk. Are you going to run out of money? Part of the estate plan needs to be considered. If you have advisors that are your attorney, your financial advisor, your CPA, and they're great people, and they haven't talked about coordination of your plans, they're failing you. It's really harsh for me to say, but the fact of the matter is these things don't work together, so they need to be talking about that. Complete planning equals legacy coordination. You've got a plan, combines into a harmonious action. So everybody here either doesn't have an estate plan, face major life changes, life changed in the last 35 years. You have a plan, I don't know what it is, I don't know who's planning it, what, or we're going to do it yourself. Every single one of those people here on this list can talk to me about what they have going on for their plan. So I'm going to ask you to please complete my intake form. You want me to know how I did today. And how does legacy coordination occur? Well, it's not by sticking your head. I love this picture. That's why I put it on there. Sometimes we have to exit our comfort zone. Stephanie was nice enough to talk about how talking about death is weird. It's not a common, easy conversation to have. But we just talked about death for an hour. You know, nobody ran out of here crying yet. So I think we're good. I'm not sure what I need. That's okay. That's why you have professionals. That's why you have these workshops. I can wait, maybe. Who likes surprises in here? I had a surprise when the year went out in front of me in September. It smashed up my car. That was not a surprise. I wanted to have it at 8 o'clock in the morning on the way to work. I totaled my car and I had to go buy a new car. My wife ended up getting a new car too, so I'm not sure how that works.
I am.
That was my wife, that's mine. I'm too busy right now, we're all really busy. Sometimes it's a matter of urgency. Sense of urgency is important. Most people focus on what's urgent and not important. That's crisis mode. If you're focusing on what's urgent right now, but it's not all that important in the grand scheme of things, that's crisis mode. That's a pretty good indicator that you're in crisis mode. The best plan is when it's not urgent, when it's important, and you can focus on it. Has anybody ever been in the zone? The zone is when you're working on something, you're working at work, you're singing a song, you're gardening, whatever, and hours just fly by. And you're just so intent on it, you do a great job, that's the zone. It's because it's not urgent, but it's important. That's how things work. So, sometimes we just need a shift. I don't know if everybody can see this. Can everybody see a pattern here? Maybe we need to change our perspective. What about now? Does anybody see a pattern? What about now? Maybe if we take a look at the quadrants. 1, 2, 3, 4, 53, 54, 55, 56, there's a pattern. All we have to do is adjust our viewpoint a little bit.
Wow.
Sometimes when you're dealing with estate planning, you just need to look at things just a little bit differently.
I like that.
So, what's it going to
Use
cost?
that in the sun.
Attorneys bill 3 ways. Billable hours, that's the most expensive. Those are litigators, divorce lawyers, that kind of stuff. Contingency fees, that's Sam Bernstein, that's Vin Johnson, that's all the other guys on the billboard posters, or flat fee. I work flat fee. If you guys decide to work with me at any time in the future, you'll know exactly what I charge. Average estate planning is about $1,500, $3,500 if you're using a lawyer. My average cost is usually about $200 to $2,200. Everybody's a little bit different. The nice thing is I've always worked with my clients. It's not like, ooh, I don't have the money. Come talk to me. We'll figure it out. It's important to have a plan. So I got a couple of free advice for you. Avoid cheap and generic when you're purchasing scuba gear, parachutes, shark diving cages, bungee cords, and estate plans. Why? Because by the time you realize they're faulty, it's
Oops.
So, in world famous firefighter Red Adair, if anybody's ever heard of Red Adair, he says if you think the cost of a professional is high, hire an amateur. What's it look like if you do decide to want to meet, you want to talk more with me, we can do a phone conference, we can do an in-office appointment, we can do Zoom, that's all good. Our first consultation, there's no charge. I don't do that. I don't charge with that. Sit down, we talk about who you are, what your issues are, and we kind of go from there. If we decide to move forward, we draft and review the plans. We talk about financial planning. We talk about estate planning. We talk about asset protection planning. We deliver the thing, we coordinate it, and we properly fund your trust. That's kind of what it looks like. That's where I'm located. Thank you very much. The other thing too, I just want to, I'm going to throw it in here, and this was not, but I love presenting, especially at churches. I don't get to do it all that often, but I do love it. So if you do decide to work with me, part of the fee, I will tie that back to the church. So, and that's something I don't always offer, but, and again, that's not to bring you guys in, but it is important. I think what you guys do is really awesome. So, thank you very much. I appreciate your time today, guys.
Wait,
And I can ask you questions. Yes.
Yes. Oh, I was gonna say I have
Please,
two questions.
bring it on.
I have two questions.
Yes.
The first,
Are these rules different from state to state and or in other countries?
Great question. So, yes, they are a little bit different state to state. However, if you put together, so probate processes for the will are a little bit different state to state. Like I made the example of California and Florida, there are some differences. So not all wills remain the same. Now, with a trust, they will likely be nationwide. What I mean by that is most trusts are written under the Uniform Trust Code, UTC, which is adopted by almost all the states. If you have assets in the trust and you die in a different state, it will still work, so you don't have to change it. The only things you may want to make sure are updated is the will, but most courts will accept an out-of-state will. There's a agreement between those states that say, yeah, we're gonna follow the conditions, and there may be some elections that need to be appropriate. Different countries, little different scenario. It depends on where the assets are. So if the assets are in the United States and there's stuff outside of the United States, you can put the outside of the United States assets into the trust, but we do need to take a hard look at the country. If there is a probate or administrative proceeding that we need to look for that, then we gotta look at tax consequences to transfer the assets. But that's a great question, so,
I have another one.
yeah.
When
Great.
someone passes away, single or married, who's responsible for the debts that's left over?
Great question, actually. So, if the debt is in your personal name and you die, the estate is subject to the debt, not the spouse. If you share the debt, and both of you are on the debt, then the spouse will inherit that debt. So if you have separate debt, the spouse doesn't have to pay for that. There may be a process through the probate, you have to deal with it. There's a little bit easier ways through the trust, that can be avoided to some extent. But if there is debt jointly, or if it's on a house, for example, because it's secured by the house, you still have to pay off that debt, it doesn't go away. But if somebody owns it, and there's not enough money to pay the debt, so you can have debt separate and joint assets, and all the assets transferred to the spouse, guess what, that debt goes away. Doesn't have to pay. So, that's a great question.
any more questions?
I can give an example on that.
Yeah.
For instance, my home, my husband and I, when we purchased our home in Mississippi, we still have 14 years to go on paying it off. Thank God that my husband had it set up that in the estate that when he passed away, it paid the house off
So you got life
through
insurance
the
on it.
bank,
That's really cool.
through the bank that we was remortgaged through. It took it from his estate and paid it off, and the bank sent me the deed.
Yeah.
Sent me the deed, and then all I had to do was take the deed to the chancellor in Jackson, Mississippi, to transfer to, and with his death certificate, to remove his name off of it and put it in my name, just my
That's
name.
awesome.
That's nice. So he did do some planning for you.
Yeah.
Yes,
My
yes.
Yeah.
And he did that like the vehicles also.
Yeah.
Since the titles was in his name, but what I did was the one that we still had 3 years to go on, I paid that off, and then I took the titles to the title company downtown, City Hall, and with it, I had to sign an affidavit fill out an affidavit on both of them, had to make sure that no minor children or anything, their names was not on it and everything. And then they had to do 2 new titles
Yep.
for each vehicle. And I had to sign off using his death certificate to do it. And
Yeah.
that's another thing.
Michigan-
I tell people,
Yeah.
don't get 1 or 2 death certificates. Get up to at least 15.
Yeah.
Because I am here to tell you.
That's great wisdom, actually, because you will need at least 10. 15 is a
That's
good
right.
number. And it's like, people are like, oh, it's $7 or $8 or $10 a piece. You will need it.
That's right.
So, and if you don't, that's okay.
That's right.
Even 10 years down the road, all of a sudden, you need an original copy. I have
Because
this
they
feel all the time.
do
I'm like,
not take copies, they want original.
they want the original
copies
certified.
on it.
That's a great point.
And I'm gonna say something else. I had a daughter that died at 21, and she did all it. But before it was over, I needed at least 11 death certificates.
Yeah.
Wow.
Just going through that process. And yeah, it's kind of, it's administrative. It becomes a bit problematic. So outfitting that stuff is really good. I always tell people, hey, have a little file folder or place that you keep all of your stuff.
Yep.
Titles, deeds, passwords. People forget about their emails and Facebook accounts and legacy plans. They do. Have that stuff written down, or at least tell somebody where they can access it. Sometimes people are like, it's on the phone, but then the phone gets shut off or something like that, and they can't get back into it. So having kind of a backup is part of the plan, part of the legacy. The other thing too that people can do, which I encourage, is sometimes you want to write a letter or do a video. Sometimes people think that's a little bit weird, but I'll tell you, it's really cool when you can leave a message for your loved ones. It's weird. But again, you just get over it, just talk to them.
Yeah.
So sometimes people do that, which is.
And like you said, my daughter left a letter that out of 7 kids, one of them wasn't by this particular person. She left that letter, and that enabled me to get custody of it.
Oh, yeah.
Because otherwise, he would send another person back, and they were complaining.
That's good. So, see, just little pieces of the plan, they all kind of come together, you know, together, which is really good. Any other questions? If you guys do want to meet with me, you need my contact information, let me know. I do have what I like to call pre-appointment things. It's not a big deal. Like I said, even if you just want to kind of continue the conversation, we can set up a 15, 30-minute call or a full meeting. Doesn't really matter. And if you think of something on the way home, let me know. I got my contact stuff. Stephanie's got my contact stuff. And I appreciate the opportunity to spend the evening with you.
Do you have any cards?
I do have different.
Thank you, everyone.
If you wouldn't mind, give me your form so you can let me know how it is, that would be great.
Sure? Oh, yeah. I'll tell them, look, oh, you got all, oh, you, okay. All right. Yeah. Thank you, Julius.
Yeah, thank you, appreciate it. Sounds good.
Thank you for helping me out. I flipped it around on me for 1 second, because I was like, oh, this good. I was saying if it's gonna flip this way, flip this way, I'm like, go now, plug it. So, yes, please. So thank you for watching and joining. I'm getting ready to end the live. Thank you. If you have any questions that I can answer with, like his contact, the lawyer's contact information, I can do that. So, okay, I'm getting ready to end. Thank you all for joining. Have a good night. Ooh, be careful. Be careful. Be careful. Be careful. Okay, baby. Be careful. Be careful. All right. All right. Good night, everybody.
The interesting thing is like I didn't know this. We talked a little bit before you did this. You could change some slides. Like, okay. It's entire 1 hour.
I'm gonna show y'all Mister. That's my husband, y'all. Okay, I'm hanging up.
Well, that's the thing. This can be pretty boring stuff.
It's very, it's cut down.
You all are so welcome. So, Pastor, they said thank you.
Thank you guys, appreciate it.
Hey, Don. Okay, I am about to end the live. I'm gonna make them available. So, good night, everybody. Thank you for watching.
Yeah, let's do it. Yeah.